Let's see if the button works this time. Thank you for being here. It's an honor to be here in Portugal and invited by the Association of Portuguese Prosecutors to be in this conference. For me, it's the second time to be here in Portugal. I was in Lisbon as well in the conference there. At that time, I was member of the board of the Association of the Prosecutors and Judges in Holland. This time I'm here as my day job as being a senior advocate general at the Court of Appeal in 's-Hertogenbosch, which is a town in the southern part of Holland. I'm going to tell you something about the public prosecution service in the Netherlands at a glance. These are the tasks we as a public prosecution service in Holland have. We are called OM, which is also common as when you talk about the public prosecution service in Holland to call it the OM, which means literally the public ministry. It's the body where the prosecutors work, and we are working in investigating criminal offences as well as prosecuting the offenders. So it's different from some other states where there's a distinction between investigation and prosecuting. In Holland, the prosecutors are leading the criminal investigations together with, in cooperation with the police, but also the same prosecutor is prosecuting the offences in court. Then we also have some other tasks, but they're minor. 99% of our work is conducting the investigations and proceeding in court the offenders. The other tasks are like, if you want to change your name in the Netherlands, you have to have the approval of the prosecution. But these are really minor tasks. As I told you, the prosecutor in Holland has the ultimate responsibility by criminal investigations, and therefore we have the authority over the national police. Not only national police, there are also some other investigative services, like on food protection or taxes. There's different investigating services. We also have the authority over them, and we conduct investigations in cooperation with them as well as the military police. But, like I heard from Tavi, not all powers some other countries have, we also have in the Netherlands. For example, we need some permissions of courts when we want to wiretap or add some listening devices or house searches. We have to, as prosecutors, ask for the court for permission to do these kind of coercive measures. But it's not the police who is in contact with the judges. It's always through the prosecution service during an investigation that we ask the court for permission for these measures. Prosecution is the main part of our job, begins as soon as the courts are involved in a case. For example, if the police arrest a person and we want a pretrial detention order, it's the prosecutor who brings the person to court and asks the court to have him in detention before the actual case is tried before the judges. We are a small country, not as small as Estonia. We are 17 million people, but of course we are quite small in square kilometers. We're a small country with a civil law system. Its origins go back to the Roman law and the local customs. Grotius is one of our main leading lawyers from the Middle Ages. One of the most important parts in our history is the period which we call the French period. It's 1795-1813. It's Napoleon. He had a big influence in Holland. And a lot of our laws originate from that period. The organization as we know it right now dates from 1813. And from 1926 we have a code of criminal procedure. We are a country with civil law system, as I told you, a continental inquisitorial system, which means that the judge plays an active role in the court proceedings against the accusatorial system, where the judge is a more passive role. Here it's really an active judge. He can also ask questions in court or ask for further investigations. But, and that's different to some other countries, our Public Prosecution Service is also part of the judicial organization. By law, we are part of the judiciary. Next to judges, prosecutors as well are part of the judiciary. When we work, we have some options to handle criminal cases. We can, of course, refrain from prosecution. It's called the principle of opportunity, and don't do anything. But if a victim, for example, thinks that we should proceed with the case, they can file a complaint at the Court of Appeal. They listen to what the victim has to say, and we can get an order from the Court of Appeal to prosecute. But it's also possible for a prosecutor in Holland to do an out-of-court settlement. We can give fines, penalties to offenders, which is normally done with the minor cases and a lot of traffic offenses. But we also have the possibility to impose sanctions. It's limited to only the minor crimes, which have maximum imprisonment sentence of 6 or 8 years. Don't know exactly. But these type of crimes, we can do sanctions as well, but only if the suspect pleads guilty, and the sanctions can be community service, or perhaps you lose your driving license for a period, but it's only limited for a small amount of hours community service or a small period where you lose your driver's license. And if you don't agree as a suspect, as a defendant, you can go to court, and then the case will be transferred to the court to be dealt with. And of course, it's the major part of the decisions we take is we can summon the people to come to court, to appear in court as well. Courts in Holland operate either in a single judge chamber or a chamber of 3 judges. The minor cases, of course, are dealt with a single judge, and the more severe cases are dealt with a chamber of 3 judges. It is a judge who presides over the court sessions. He interrogates the defendant, the witnesses, and the experts in Holland. But the public prosecutor, and after them the defense counsel, are allowed to cross-examine the defendant, the witnesses, or the experts. And also in Holland, the position of the victim has increased over the last few years, and he has the right to make a statement in the more severe cases. The victim is invited to court, and he can stand up and tell the court what he has experienced, what his feelings are about the case, but also what he thinks would be the best sentence for the suspect. After that, the prosecutor in Holland makes his closing speech with a judicial proposal to the judge or judges. It's called the requisitor. It's a French word, so we still borrow some things from our French period. And then there's a closing speech by the counsel for the defense. After that, the prosecutor has a second term. He can react and respond to what the defense counsel said. And after that, the defense counsel has a right to respond to the second time the prosecutor makes his statement. The defendant is always the last one to be allowed to give his last words. And after that, the court decides about guilt or punishment. And when there's a single judge, it's normally done immediately. When there are 3 judges, it's normally done after 14 days. Of course, there's also in Holland, because this is the first instance, the possibility of appeal. It's a more or less the similar procedure like this. After 2 weeks after the decision, you have to sign for appeal, and then the case is transferred to the Court of Appeal in Holland, where the same procedure goes as in the first instance. Only the prosecutor is called an advocate general in the second instance, but for the rest, the work is the same. The sanctions which the judges can impose under Dutch criminal law are imprisonment, fines, but also alternative sanctions like the community service, but also training orders. For example, for drug addicts or other people, you can give them special orders to get their life sorted out and not to be again in court. It's done a lot and it's gaining popularity. Next to the sentences, we also can ask for some court orders, like the confiscation of items, usually by cars or money in cases. Like told by Tavi, there's also a possibility for the recovery of proceeds of crime. When we can prove that, for example, the growing of weed is a crime commonly in Holland, when we can prove that the suspect has grown it for several months and he must have gained some profits by it, we can ask the court to recover these proceedings from his crime. A compensation order is also part of the possibilities for the judge, compensation for the damages suffered by the victim. And also two measures, some people, when they are diagnosed by psychologists and psychiatrists, are not fully accountable for what they're doing. They can get a mental hospital order so that they are treated. And every 2 years, if it's given by the court, it's checked whether it should prolong. I believe the average time people stay in TBS is 7 to 8 years. A second court order measure we have since some decades is the ISD. It's an institution for repeated offenders. A lot of people come back again and again to court because they are drug addicts and they come all the time to the courts. We have a special measure where we can put them away in an institution for repeat offenders where they will be treated for 2 years. There's some conditions. We can only ask for a court order if the person has been reported by the police 10 times in the last 5 years, of which 3 of these reports from the police has led to a conviction. Of at least one of them should be in the last year. In these cases, and usually it's drug addicts, they can get the measure of to be put in the institution for repeated offenders for 2 years. For minors, we have a different system. People up to 18 years are considered minors by law. For the very simple cases, for example, a 12-year-old is pickpocketing or shoplifting for the first time, they can be reprimanded by the police or the city council. It's called halt, which is the Dutch word for stop, because we think that in the beginning the sentences should be according to the age of the suspect. But if it's more severe, we can fine or punish minors by short community services or training orders up to 80 hours of community service by the prosecutor himself. In other cases, the prosecutor summons the minor to appear in court before a specialized juvenile judge. One of the other tasks of the prosecution service is also taking part in tripartite consultations, because as well as the prosecution service, also the mayor of a city has authority over the police. I put a small figure there. It's not very accurate because when you look at it as a triangle, it seems that the mayor is in the top position, which he isn't, because as well as the mayor and the prosecution service, they both have the authority over the police. But we have regular consultations with mayors of big cities because we have to allocate the scarce police resources, and we discuss, and usually it's the chief prosecutor of a special office who talks to the mayor to see whether there are problems in certain areas of a city or a region, and to allow police to make more surveillance or to start some investigations on specific problems in specific parts of the city. So these are done in cooperation with the mayor of the cities. As well, in other European countries, the position of the victims has gained a lot of interest in the last years. And I must say, I'm an advocate general. I'm 1 or 2 days a week in court myself. And I must say that the improved position of the victims satisfies me as a prosecutor a lot, because for victims it's a big bureaucracy they are facing, and we have a talk to a victim. You can give the bureaucracy face, and you can really hear what they have suffered. And for the victim, it's very satisfying to know that at least one person on stage is aware of what he has been through and what he feels like. It's our duty to inform the victim also about the progress of the case. We have to inform him about the possibility of compensation and to tell him that he's also entitled to make a statement, as I told you, in court. And as I told you, he has a right to have a contact with the public prosecutor. Usually it's done 1 or 2 weeks in advance before the case, that there's an appointment and they meet in our office. There's a special victim support desk manned by police, Dutch police public prosecution service and the victim aid. And the victim has also the right to be assisted by a lawyer in court. This is the organization of the OM. We are with 5,000 colleagues, which of them are 900 public prosecutors or advocate general. 1/3 of our cases are the more minor misdemeanors, the traffic offences, and the very small cases, usually dealt on magistrates' courts as a single judge. 2/3 are the criminal cases, of which half of them really go to court. My organization at the top has a board of Procurators General. It's usually 3 to 5 Procurators General. They were all prosecutors. Now the law has changed, and it's possible for the Procurator General, Procurator General who is in charge of the finance, to have one member of the board who's not an actual prosecutor itself, because it's also a real profession to talk about finance and to manage an organization like the OM. In first instance, we have 10 regional OM offices at the district courts and 3 national OM offices for specialized crimes. One is called landelijk. When you translate it, it means national, which might give some misunderstanding with the PPS, but it deals with specific cases, and so does a functional and central office. I'm going to tell about them later on. And 1 Court of Appeal Public Prosecution Service instance with 4 local offices. See if yes. The Board of Procurators General, sorry for my pronunciation, it's a difficult word, 3 to 5 PGs, 1 chairperson managing the entire OM. They're responsible for governance, money, ICT, staff. They issue the guidelines so that all similar cases are dealt with in a similar way in the entire country. They issue our internal rules, and they also have a role in the decision on very sensitive cases. But they don't do actual cases themselves in court, and they are the single point of contact with the Ministry of Justice. The head office is the Parquet General, which supports them as the organization. This is my country, where you see the 10 local regional offices, and the white dots, A to E, are the E to B, D are the 4 courts of appeal. You see 2 times B because there are 2 regions, but they work together in 1 office. 10 regional offices called Parketten in Holland, with 1 chief prosecutor, team managers, senior prosecutors as well as normal prosecutors and junior prosecutors, but also an equal number of legal staff to assist prosecutors, so they don't have to do all the work themselves. We have a very big number of legal assistants who assist us by our work. And one thing I'm quite proud of is what we call at the bottom ZSM, the super fast lane for simple cases. ZSM is the Dutch abbreviation for what we call in English as soon as possible. It's open 7 days a week, at least 14 hours a day. It's an office, usually not in the office of the prosecution service itself, but usually somewhere else or with the police somewhere, where always at the opening hours a prosecutor with his assistants is available but also the probation service, victim aid, police, childcare. They're always present there for simple cases. They're directly transferred to ZSM, and within 1 or 2 hours we can give a decision with consultation of all the parties. They can hand over the summons or the file, the fine, to the suspect. So it's a really super fast lane. And we also use it, for example, when there are big football matches and you expect trouble in town. You can expand the opening hours from 14 hours to late at night. It's a development from the last decade, and a very large number of cases is dealt with via the ZSM procedure. As I told you, there are 3 specialized public prosecution offices: the National Public Prosecution Office, especially for the larger cases on a national or international scale, organized crime, terrorism, but also cases which require a special expertise. Then there's what we call the functional parquet. It's a financial, environmental and food safety offences office. Specialized prosecutors doing investigation with the special services like FIOD, which is the tax police. They do the tax investigations, and some other specialized services. And we have a central processing office where we do all the on a national scale, all the minor summons are made, for example, for traffic offences. We have some other departments within our organization, scientific office for criminal law studies. We also have a special department where we handle corruption cases within government and public figures, serious police farm incidents. It's the National Police Internal Investigations Department. And we have a service center, but it's more to support us on staffing, finance and other information and facilities. Also, each regional office has its own IRC, one in each district and one national, just to handle all the mutual legal assistance and the handling of incoming and outgoing questions in the cooperation with other countries. But who monitors the PPS? We are independent, but we have 2, and I put it between quotation marks, authorities, because of course they're not real authorities, but in the end it's of course the judge who decides whether we did our work in a correct way. And also, because we're tax funded, funded by the public funds, it's the Minister of Justice who has to be accountable in Parliament if we give the taxpayer value for money and if we do our work properly. The Minister of Justice is accountable in Parliament for law enforcement, for everything we do as a public prosecution service. And as a rule, it's a task of one of the Procurators General, usually the Chief, to inform him about what's going on in our organization. And he cannot interfere with individual cases because independence is, of course, like said earlier before, very important. There's one theoretical exception. There's a provision in law which says if the minister wants to give a provision, I don't know of any case, if it's ever happened, I don't know of any case where it has happened, but in that case he has to give a warning first that he is intending to give an instruction, and if so, if he wants a prosecution, it has to be completely transparent in the files, and if he doesn't want the prosecution, he has to be inform Parliament that he has so. But as I told you, it hasn't happened since, as far as I know. Okay. And to conclude my presentation, it took longer than I expected, sorry for that. As I told you, it's important, as earlier speakers said, to have a PPS which is impartial, which is independent and completely transparent. And therefore it's also laid down by law that prosecutors as well as judges are part of the judicial organization. And as I started, that's why we also have a trade union in Holland, which are both judges and prosecutors, the same association. Thank you for your attention.